Morning students, welcome to my presentation on public interest litigation from the course Social Welfare Administration and Legislations Unit 3. Uh, Public interest litigation has become a famous term which has been widely used and known to many of us, and this is a concept which has been evolved to protect the rights and the privileges of the unrepresented groups. So public interest litigation as an expression has been borrowed from American jurisprudence, where it was designed to provide legal representation to the underprivileged or unrepresented groups like poor, racial minorities, unorganized consumers, citizens who were passionate about the environmental issues, etc. So the term public interest is the interest belonging to a particular class of the community that affects their legal rights or liabilities. This concept has its origin in USA in 1960s. Public interest litigation is not defined in any statute or in any act, and it is a power given to the public by courts through judicial activism, and it has been interpreted by judges to consider the intent of the public at large. However, the person filing the petition must prove to the satisfaction of the court that petition is being filed for public interest and not as a frivolous litigation by a busybody. So we can see that public interest litigation as a concept is the litigation filed by any common man who is much interested or who is working for the welfare of the socially disadvantaged sections. When these people are not able to talk for their rights, when they are not able to go to the court to get their rights, and someone in the interest of the public, they file a case in the court of law for their welfare and for their favor to get justice done on their behalf. So what are the matters that come under public interest litigation? So we see that matters concerning bond labor and the problem of neglected children, the children neglected by their parents, and concerning the casual workers, the problem faced by the casual workers and their exploitation and their payment of wages, in the sense they are not paid well, or non-payment of even the minimum wages. So all these things come under public interest litigation. Even for the welfare of the women, when there is a atrocity against the women, public interest litigation can be filed. And when there is a disturbance of ecological balance and environmental pollution, a person who is interested in environmental safety, environmental concern, he can file a public interest litigation, as this pollution is causing environmental degradation and disturbance of the ecological balance, which in turn affects the public at large. Then food adulteration. It's also matter which disturbs or which cause health issue to the public. So this also can be filed under public interest litigation. And maintenance of heritage and culture, and this is also considered as fundamental duties of every citizens. So when things are going against the maintenance of the our cultural heritage, then a person can file a public interest litigation. So having said that, we now move on to the meaning of public interest litigation. So PL means litigation filed in a court of law for the protection of public interest. Any matter where the interest of the public at large is affected can be redressed by filing a public interest litigation in a court of law, such as pollution, terrorism, road safety, construction hazards, etc. So you can see the famous personality from Tamil Nadu, Mr. Traffic Ramasamy, who is well known for filing a lot of public interest litigation against traffic problems, road safety. Especially, he has filed a litigation against politicians for keeping the banners at the roadsides of cities and towns and so on. And he is a well-known figure for PIL. Um, According to Supreme Court, in the case which was verdicted in 1993, Janata Tal versus H.S. Chowdhury, the Supreme Court has given the definition of public interest litigation. So PL means a legal action started in a court of law for the enforcement of public or general interest, where the public or a particular class of public have some interest, even including the uh, pecuniary interest that affects their legal rights or uh, liabilities. So can see that public interest litigation, uh, in a way, it is for the protection of the public interest. Any person can file uh, litigation in the court of law to get justice done. Now we discuss the evolution of public interest litigation in India, how and when it was originated, and what are the landmark judgments no, on public interest litigation. The seeds of the concept of public interest litigation were initially sown in India by Justice Krishna Iyer in 1976 in Mumbai Kamahar Sabha versus Abdul Dai case. The first reported case of public interest litigation was Husainaira Khatun versus State of Bihar in 1979 that focused on inhuman conditions of prisons and under trial prisoners that led to the release of more than 40,000 under trial prisoners. Right to speedy justice emerged as a basic fundamental right which had been denied to these prisoners. The same set pattern was adopted in subsequent cases, and a new era of public interest litigation movement was heralded by Justice P.N. Bhagavati in the case of S.B. Gupta versus Union of India. In this case, it was held any member of public or social action group acting bona fide can invoke the jurisdiction of the High Courts under Article 226 or the Supreme Court under Article 32, seeking the redressal against the violation of legal or constitutional rights of persons who, due to social or economic or any other disability, cannot approach the court. By this judgment, public interest litigation has become a potential weapon for the enforcement of public duties where the executive action or misdeed resulted in public jury. And as a result of any citizen of India or any consumer groups or social action groups can now approach the apex court of the country seeking legal remedies in all cases where the interest of general public or section of the public are at stake. And we also see other cases on PIL. The Supreme Court in Indian Banks Association, Bombay, versus Devgala Consultancy Service held that where the petitioner might have moved a court in her private interest and for redressal of the personal grievance, the court in furtherance of public interest may treat it a necessity to inquire into the state of affairs of the subject of litigation in the interest of justice. Thus, a private interest case can also be treated as public interest case. And we also see MC Magda versus Union of India in a public interest litigation brought against Ganga water pollution so as to prevent any further pollution of Ganga water. The Supreme Court held that petitioner, although not a riparian owner, is entitled to move the court for the enforcement of statutory provisions, as he is a person interested in protecting the lives of people who make use of Ganga water. So in this verdict, we can understand that the court was much uh, serious in discharging the justice and the rights of the vulnerable sections, even when someone on their behalf comes to plea to the court. And we also have the Vishaka versus state of Rajasthan, the famous judgment of the case recognized sexual harassment as a violation of the fundamental constitutional rights of Article 14, 15 and Article 21. And we see the guidelines also directed for the sexual harassment of women at workplace prevention, prohibition and redressal act 2013. Litigation filed by a person against this sexual harassment uh, uh, took place in Rajasthan against the women Vishaka. This even very strongly brought a act called sexual harassment of women at workplace prevention, prohibition and redressal act 2013. And we see the Bandhua Mukti Morsha versus Union of India in 1984. This case dealt with the exploitation of bonded laborers and was the first PAL filed by NGO. So we see a lot of cases. One or two cases I just want to enlist. Uh, Rural litigation and entitlement Gadra versus state of Uttar Pradesh in 1985. It dealt with the mining activities that had led to environmental degradation, deforestation, and displacement of local communities. The Supreme Court recognized that the right to a healthy environment was an integral part of the right to life under Article 21 of the Indian Constitution. Having discussed about that, now we move on to a very important topic: the factors responsible for the increase in a PIL case in recent times. So we see that public interest litigation today has become very famous, and people are made aware of this. And recent times, many public interest litigation cases are filed. So what are the factors we can see? As I said earlier, the first one is the awareness, the education. So there is an increased awareness about the legal system and human rights, as well as a greater access to education, which has led to a rise in the number of people who are able to understand as well as use a public interest litigation mechanism to bring about social change. And second, we see the strengthening of legal system, particularly the judiciary has made it easier for individuals and groups to access to the courts and file cases. Our Supreme Court's formulation of guidelines for PIL cases has also made the process more transparent and streamlined. And above all, we could see the media coverage, the growth of the media and the increased coverage of public interest litigation cases has brought public attention to issues that would otherwise have gone unnoticed by many. And we see the increased activism also by the growing number of individuals and groups taking up public interest issues and using a PIL mechanism to bring about change. And we behind this we also see the public political support, the support of the political leaders for public interest litigation cases also help to increase the number of PIL cases recent times. So having said that, we now discuss about the procedure to file public interest litigation. Uh, so in a court, in High Court, two copies of the petition has to be filed, and in a Supreme Court, five sets of petition has to be filed. Court fee of rupees 50 per respondent has to be affixed on the petition. Proceedings carry on in the same manner as in other cases. And the question comes, who can file a public interest litigation? Any citizen can file a public interest litigation by filing a petition under Article 32 of the Indian Constitution in the Supreme Court, and in the High Court under Article 226 of the Indian Constitution, and in the Court of Magistrate under Section 133 of the Criminal Procedure Code, a person can file a public interest litigation, and this litigation can be filed against a state government or central government or municipal authorities and so on. And we finally discuss about the significance of the public interest litigation in India. So as we say, it is a very important tool and a powerful tool which has made human rights reaching to the people, those who are vulnerable and those who are denied of their the fundamental rights. And it democratizes access to justice for all. That means any citizen or agency who is capable can file petitions on behalf of those who cannot or do not have the means to do. It also helps in judicially monitoring state institutions like prisons, protective homes, and so on. So in a way, we can see it is important and a very powerful tool in a judicial review. So having said that, as I want to conclude that public interest litigation is a very powerful weapon which is used by many social activists or social workers or human rights activists to defend the rights of the vulnerable people, vulnerable groups who cannot speak for themselves, who cannot fight against injustice, who cannot go to the court to get justice done and to you know uh, fight against the atrocities or inhuman activities or violence or the discriminations that take place in their life. Thank you so much.